Tom Jipping. Welcome to Constituting America's Constitutional Chats. We invite you to give us a brief overview of our topic today, and then we'll go to questions.
Well, thank you very much for having me. I remember our conversation in the previous one about this case, and I think I was right in predicting how the court would decide it. The way to understand this case, like so many others, is to make sure we understand what the role of the courts are in our system of government. Cases like this, especially in the Supreme Court, can, involve issues that are sometimes divisive and politically charged. And so the temptation is to evaluate what courts do, basically using our politics. Do I like what they decided or not? But that's not what courts' role is. Courts decide legal disputes between specific parties. And so Justice Clarence Thomas, for example, a few years ago, he described what judges do as interpreting and applying written law, like statutes or the Constitution, to the facts of individual cases. And so, sometimes the Supreme Court can decide a case in a way I don't like, but they might just be right. And so we've got to keep that in mind, and especially in a case like this. In this case, there's a small city in Oregon called Grants Pass. And like many cities all across the country, they are wrestling with a homeless problem. It's a very complex problem that cities are trying various ways to try to address. It doesn't really know any party or ideology. I mean, Republican and Democratic states and cities have this problem. And many cities, including Grants Pass, one of the things that they do, Grants Pass passed an ordinance prohibiting the homeless from camping in public spaces. And these would be things like public parks, but also streets, sidewalks, people's driveways. Part of the addressing the problem includes that restriction, and it's for a couple of reasons. Number one, everyone in the community has a right to be safe and to use public spaces, but also the city wanted that to be an incentive for homeless people to accept shelter space that does exist. I was surprised to learn that, in many cities, up to 50% of the attempts by city workers to help homeless people get shelter, the homeless refuse. And so this is also an incentive for that. So this is something they were trying. But of course, in America, lots of things that start out as, efforts to address problems end up in court. So this lawsuit challenged that ordinance, that anti-camping ordinance. And the plaintiffs argued that it violated the 8th Amendment to the Constitution, which prohibits cruel and unusual punishment. And the lower court, the U.S. Court of Appeals for the Ninth Circuit, which is kind of the western third of the country, they had already decided that, yes, those kind of ordinances do violate the 8th Amendment. And so that issue went to the Supreme Court, and the Supreme Court 6-3 disagreed, and they reversed the Ninth Circuit. And here's where the proper role of the courts comes in. The 8th Amendment says cruel and unusual punishment. Well, we all know what punishment is. I certainly did when I was a kid. And, punishment is the consequence of conduct that is prohibited. It's not the conduct itself. And so here, they were challenging the ordinance that made the conduct a crime, or it was just a civil offense. But they were challenging an ordinance that had to do with the conduct under a constitutional amendment that had to do with punishment. And that's kind of like a square peg in a round hole, and they just don't fit. And the Supreme Court said that when the 8th Amendment uses the word punishment, it means what it says. And therefore, the 8th Amendment cannot be used to basically take off the table an approach like this, an ordinance like this that a city wants to use. Maybe there's other constitutional arguments that could be made, but the Eighth Amendment, it just doesn't apply. And in this case, you had, hundreds of cities, counties, states from all over the country, everybody from Governor Gavin Newsom and cities like San Francisco to, conservative states like Idaho, conservative think tanks and liberal groups. You had everybody across the spectrum weighing in here saying, that the Constitution just doesn't say anything about this. Obviously, when the Constitution does take off the table certain options that a legislature might want to try, you have to obey that. But here, judges were making something up. They were taking a constitutional provision that really didn't have anything to say about what they were trying to do, and some judges were trying to use it to basically force their own ideas about how to handle the homeless problem onto cities, and that's not their role. So I think it was a right decision. Justice Neil Gorsuch wrote the majority opinion. Justices Sonia Sotomayor, Elena Kagan, and Ketanji Brown Jackson dissented, and they basically took that that liberal position of, we think that this is how the homeless problem should be addressed. And if we can kind of shoehorn that into the Eighth Amendment, we think that we ought to do that. But I think the majority got it right. These are hard problems, but we have to remember that the people we elect, whether it's to Congress, a state legislature, or here to a city council, the people we elect have the biggest responsibility for addressing policy issues, and this is certainly one of them. And unless the Constitution clearly, kind of steps in and dictates what they have to do, our elected legislators have to have the freedom to do their job. And if we don't like it, we can say so in the next election, but it's not up to judges to step in and to say how these problems should be addressed. So I do think it was a right decision, and a rare one where you had a lot of different folks, left and right and center, agreeing on it.
Well, thank you. That was a great summary, and just very interesting to hear how it came out after our previous discussion about it. Janine, I'm going to go ahead and turn it over to you.
Okay, yes, thank you very much. So essentially, those advocates that it was cruel and then it was a punishment to were saying there's a law, but this law is a punishment. Correct? That's what they were trying to say.
Mixing those two up, trying to, like I say, kind of shoehorn a law that prohibited certain conduct and kind of act as if it punished certain conduct, which it didn't do. But it was about the only argument that they had.
Right. So in a way, that's you have to kind of stop that domino effect. I think that precedent, if they had made an opposite decision where the law was punishment, how do you stop that domino effect of anyone saying, oh, it's law that I have to stop at a stop sign? That's that's punishment. That's cruel punishment. I mean, it seems to me, I can't believe even 3 Supreme Court judges dissented, because as you say, you don't want to legislate from the bench. This would be a classic example. It had turned around the other way. But if you have a law that the legislators have actually passed and the people have voted for the legislators, and then people come around and say, oh, punishment, how do you stop that from applying to any other law that might come along?
Well, you do what they did here. The city of Grants Pass, when the Ninth Circuit ruled against them, they appealed. And they went all the way to the Supreme Court to get the right answer. The way that you framed it, I think, is really good, because once a decision gets on the books, at least for that court, in this case, the Ninth Circuit had decided, I think it was maybe 6 or 7 years ago, that a law like this violated the Eighth Amendment. And then you just have the ripple effect of it gets applied over and over and over. So either that court has to change it, which they refuse to do, or you have to appeal it as high as you can, and that's what happened here. Hopefully, the opinion is, I think, clear enough, and it sends the right message that folks won't try to do this kind of thing in another context. But you're right, once a bad decision gets out there, it can do a lot of damage. It can be very hard to undo.
Well, yeah, that word called precedent, right?
Mhm.
In this case. But also it's interesting to me that that the ones that were saying it was, punishing them, that when they had to abide by a code of conduct that the legislatures, thus the people, had already put in place. It's interesting to me that they decided to go to the courts instead of trying to work within their own township, their own sense of legislators, their own representatives, to say, we're going to write a petition, let's change the law. It's interesting to me that it didn't take place there, that they skipped that very important sense of the American process with our Constitution, and decided to go straight to the judges to take care of this, to the courts.
Well, I don't know that they never tried that, although, since the Ninth Circuit had already kind of answered this question, they knew that anybody would know that that would really be hard to overcome. And, it happens a lot in this country where if you don't think you're going to win in the legislature, try going to the courts and roll the dice. I don't think
Do
that's
you agree with that?
no,
I know
no,
we have the right to do that, but do you agree with that process? And it's really not the way the
no,
process is supposed to work.
not at all. For a couple of reasons. Number one, especially when the Constitution is involved, where you end up treating the Constitution like it doesn't mean anything, or it can mean anything that you can kind of get a smart lawyer to make it mean. And second, look, federal judges especially, they aren't elected. They're not. So what do you do if ultimately the Supreme Court renders a bad decision? Keeping things that belong in the legislature lets the people exercise some accountability and respond at the ballot box and try to influence their legislators, just like you suggested. So that's the way our system is designed. It's the best way for our system to work. I know everyone wants to win, but sometimes we try to win the wrong way. And this was the wrong way to try to do it, to go through the courts.
Interesting. And our just for our young listeners and people who are new to this topic, since it's part 2 for us, this was a township. It was a town, a law in a town, right?
A city.
And that is the city. Which city was it again?
Grants Pass, Oregon.
Oregon. Okay, so a city in Oregon said the homeless cannot sleep in the park or the streets.
Right.
Correct? Okay. So it's also interesting that you have a township. We're reading Democracy in America. Lacey's really shown us the wonders of democracy in America. Thank you, Lacey. And that's our new 90-day study. And but the impetus on townships, and that the people in their local should be able to handle their own issues. I don't know if our founders ever really expected that they would take it all the way up to Washington, D.C. to decide something that should be happening in a township, so to speak, our city.
Yeah, I think
But I mean, I know it happens all the time, but we're really supposed to take care of it in our own neighborhood.
well, there's 2 dimensions to that. Number one, we're supposed to handle most of these things in the legislative branch, not the judicial branch. And then second is what you're referring to, which is most of these things should be done at a lower level of government. So, yeah, I mean, legislatures at the more state or local level is where we're supposed to be handling a lot of these things. And this problem of homelessness is a great example of why that's a good idea. It's a very local problem. And different locations might have the same general problem, but the factors that go into what's happening there can vary a great deal. And so you have to have those local legislators handle it, and they have to have, as many options as possible for addressing these things. We've been talking here about the one ordinance in Grants Pass prohibiting camping in public, but that was only one of probably 7 or 8 different ordinances that they passed trying to address different parts of the homeless problem. And, you know, unless the Constitution's clear, judges shouldn't step in and start, you know, reconfiguring and getting in the way of what those local legislators are trying to do.
And if we didn't have, you know, the media that we have today and the mass fast communication, I mean, if you think about this problem in the 19th century or the 18th century, they just would have taken care of it locally, really, right? It would have just been, hey, we all voted for this in our township, and this is the way it is, and you know, change it next go around.
Yeah, no one would have suggested that the US Constitution, which we can all read and all of us should, had anything to do with how a local city council addresses homelessness.
And why, my last question, why did the Supreme Court take it? You know, you hear often about there's no standing and they send it back to the lower courts and they say, we're not going to take this case because it's really not for us. Why, and they get so many cases and they only choose a handful of them. Why do you think that they, since this was such a local situation, why do you think they took the case in the first place?
Well, the case started locally, but of course, it was a federal court of appeals that ruled on it. The most common reason why the Supreme Court takes a case is if 2 of these courts of appeals, the Ninth Circuit versus maybe the 4th or the 1st or something, decide the same issue in opposite ways. That's the most common, and that was the case here. Several other circuits had addressed the same issue, but they'd all addressed it differently than what the Ninth Circuit did. So you had what's sometimes called a circuit split. You know, two courts of appeals disagree, and the Supreme Court, because it involved a constitutional question, the Supreme Court felt it was important to sort that out and to settle the conflict.
That's really interesting to know. So it was because that's sort of is what the Supreme Court does. It steps in when there's a kind of a conflict between states or a conflict, obviously here between the 2 courts. So that would be their basis for taking it.
Most cases involve that sort of thing. There are a few cases that actually originate in the Supreme Court, but I'd say probably 90–95% of their cases involve this sort of thing where there's lower courts disagree or states are suing each other, that kind of thing, and that's why the Supreme Court has to address it.
Interesting. Okay. Yeah. Well, there you go. Hey, look, I stopped right on time today. Thank you very much. Appreciate it, Thomas.
Well, thank you, Janine. And Joel, we're going to go to you.
All right. Thank you very much for there's a lot of clarity in your explanation. We appreciate it. I'm almost, it just seems like clear law, like judicial activism to try to bring this under the 8th Amendment. And I want to know if there's any saving grace for that, because from your explanation and from us reading the language, I just can't see how you could shoehorn this in and honestly believe that that is sound political theory.
Well, that's why I started with the idea that, you know, we have to get clear on the basic principles of how is our system of government designed, what are the different parts of it, and like the judiciary, and what is it supposed to do, and how important it is for each part to kind of stay in their lane, you know, to do their part, but try not to kind of stick their nose into others' business. And there's very different views on that. Our founders designed the system to have a modest and defined role for each branch of government, and they really stressed how important that separation of powers is. And as we started drifting away from that, all kinds of problems, exist. It's interesting that the founders wrote the Constitution down. We have the oldest written Constitution that's still in operation today, and it's also one of the shortest. But the founders said they wrote it down so that everyone would know what it said. Everyone would know the limits that it places on government. I don't think they expected, in light of your question, I don't think they expected courts to try to shoehorn things either, to pretend that one word means something else. I think the key is to appoint judges who really have a conviction about that limited, defined role. It's tempting for judges, federal judges are very powerful, and it's tempting for them to want to address policy issues and to solve homelessness and all this sort of thing. But you have to appoint judges who really understand the limits of judicial power and are really committed to kind of sticking to their job description.
I think that why it may bring us a little bit back to the case, but I just wanted to ask you something and make a broader implication to this case, because there's more interesting questions that it touches on if it's removed from the Eighth Amendment, which are things like what is citizenship, the role of government, the limits of local government, and something that we don't use very much anymore, but is property. We don't use the words the way that the founders use them, but that property rights and what that meant to them, and land ownership, and government owning land, people owning land, and how we've commented many times on the show about it was changed to pursuit of happiness, but right, life, liberty, and property. So in this case, just a comment on, it would be interesting to hear discussion on the right of the homeless in a city. Are they a citizen of that city? What constitutes their citizenship in this municipality, and how is that decided? And then, the other thing it really touches on is a show we did a little while back was on the rights on the powers of local government. And it seems like local governments exert powers that infringe on rights, but they no longer balance federal power quite often. We see citizens of a city are being infringed upon at every level of government, and those levels are not balancing each other as was hoped for, as was designed. So we see things like, if our founders would really see how permitting works, or how the basis of things like how we go about assembly. It'd be interesting to hear those questions from just, hey, camping on public ground. Well, what constitutional and philosophical questions does that bring to light? Is our land, when I camp, did I disenfranchise another citizen's equal right to that property? And if not, then what constitutes my not being allowed to do that? These are questions I think we'd really benefit from, but so often what I seem to see so much in all of these high-profile Supreme Court cases is more of an approach of semantics and less of an approach of the philosophically what our form of government's meant to be, and handling all of these modern things in the light of our founding principles, which we can pretty clearly see because we get to go back and look at what they wrote, like you said, and we get to look at how they decided things, and we can still say, hey, they got that wrong. We got to talk about it then.
I think one of the benefits of sticking to the design of our system, where judges decide legal disputes by objectively interpreting and applying the law, there's less controversy over how they specifically resolve the legal question. And then there can separately be discussions of the sort of issues that you're talking about, implications of the decision, principles that are behind the decision. Instead, today, when you have basically politics mixed all up into the legal issues, so that the only question on the table is whether, the decision in this case kind of jive with my politics, it's very hard to have those kinds of separate important conversations about principles, because you're fighting over what should be very settled, which is the Constitution says X, it applies to this case in that way, and so that legal dispute is settled, and then we can talk about all these other important issues. With regard to property rights, one of the reasons I mentioned earlier that there were kind of two reasons for ordinances like this with regard to camping in public. One of them is the property rights, but it's the property rights of property owners, people who own property and their homes, and those rights get infringed upon too. I mean, we are, addressing an issue of homelessness is important, but there's more involved than just the homeless and a policy that affects them. And that's why a policy like this, we shouldn't forget that that's an important part too. People, other people live in that community. Other people have a right to use public spaces. And yeah, those are one of the reasons why I'm a big fan of Constituting America is that, our fellow citizens know less and less about those basic fundamental principles and those philosophical issues about government itself. They know less and less about that. And, the founders built, the Declaration of Independence says when you establish a new form of government, you have a foundation of principles and an organization of powers. And, I wish that more of our fellow citizens understood our system in the same way. So, like I say, kudos to Constituting America for trying to fill in some of those gaps and to help people understand our system better.
As my final question, I just wanted to come back to some of the things Gene saying about implications of if it was ruled the other way. It's hard to even fathom all of the different ways that we would then be talking about. Well, then what's next? What would jurisprudence be? Could you talk about some musings on what you think may come down the pipeline next if they had ruled it the other way, or what some of the really big issues it would have caused or conflicts it would have caused in prior rulings or law?
Well, kind of an anecdote just came to mind. I'm not even sure what this is stored in my memory banks, but my younger brother has two sons. And when one of them was very young, he was at my parents' house. They were babysitting, and this is the way my mother told me the story. He had kind of a glum look on his face, and she said, "Well, what's the matter?" And he said, "I did a bad thing, and I'm going to get a bad consequence." Now, he understood the difference between what I'm not supposed to do and what's going to happen to me if I do it. The difference between the crime and the punishment. Even kids understand the difference between. But if this decision went the other way, if the Supreme Court did what the Ninth Circuit did and mixed those two up, you would have people challenging every law they didn't like, especially every criminal law, leaving it to judges to make these subjective, vague, conclusions about what seems to them to be punishment. And by mixing up all these categories, you're simply empowering judges to control more and more and more of our lives. And, we have too much litigation in this country to begin with, and that would make it much, much worse.
Thank you very much. So pass to Wyatt. Awesome. Thank you.
Alrighty, well, just want to first off, thank you so much for talking about this and being here. It's a very interesting conversation. So as you were saying, you said that you believe that they made the right choice. And even before, you had support from like more liberal states like California and then other more conservative states kind of coming together and saying, in support of cities having the power to, enact these ordinances. But were you surprised that the court fell on party lines when support from the other ones were not falling on those party lines?
I was. These days, for a number of reasons, the media especially really focus on the Republican appointed justices and the Democratic appointed justices. And they almost never tell you that a majority of Supreme Court justice decisions are unanimous. I mean, they paint this picture that it's always this stark divide. That said, once I was reviewing, in fact, I did that before I was here for the previous discussion of this case, and looking at the list of the different cities and organizations and states and public officials from across the spectrum who were all taking the same side. I expected it to be unanimous for that reason, that there really wasn't so much an ideological, divide here, but it turned out to be. And I attribute that primarily to what we, were discussing earlier, and that is just a very different view by those three dissenters about what their power is. How much power do they have to pretty much dictate the outcome of these cases? The six justices have a more modest view of what that is. And so that's why you do sometimes see a 6-3. But, I do want to emphasize the large majority of Supreme Court cases are either unanimous, 8-1 or 7-2. So it isn't that way all the time. But I did expect, and I had hoped that it would be more closer to unanimous. And I also wish that justices would apply these principles more broadly, because this is the method the Supreme Court is supposed to use, no matter what a case is about. They're supposed to look at the text of the Constitution and interpret it objectively, not through a political lens. And I wish they'd do that consistently. They did it in this case, and that was good. But I wish they would do it more consistently.
And then I know we've talked about some of the implications it could have had, but now since that they have decided, that these ordinances did not go against the cruel and unusual punishment clause, how do you see this case and its ruling impacting future cases dealing with the exact same clause?
Well, if I had to pick one or two clauses of the Constitution that the Supreme Court has messed up more than any other, the cruel and unusual punishment clause would be one of them, I'm afraid. For the last 60 or 70 years, the Supreme Court, particularly in the criminal law context, has basically said cruel and unusual is anything we don't like. I mean, it's really been a misreading of the Constitution. Jewel had mentioned the phrase judicial activism. That's really what it's been with this clause, and it's really caused a lot of problems. So, a lot of those problems remain just because they got it right here. Although, every time there's a decision like this, which stands for the principle that the Constitution's text means what it was intended to mean. Now, it would maybe be another show. We could talk about a dozen different ways in our daily lives where we believe that principle. I mean, when I got creative about what, trying to get away with something my parents told me not to do, they told me in no uncertain terms, no, it means what we say it means, But every time there's a decision like this, a good one that says the Supreme Court, they have to look at the Constitution objectively, and they can't mess around just to get their way. It does add a good thing to our understanding, but that provision of the Constitution's been really messed up for a long time, and judges kind of take it and run with it and almost treat it like a blank check sometimes. As I said before, the solution to all of these in the long run, you have to have judges who not only understand their proper designed role, but they really have to have a conviction that they're supposed to stay in their lane. And we get some of those justices now and then. I think we have a majority of justices on the Supreme Court now who are like that, but when there's a majority the other way, they can do a lot of mischief.
Mm-hmm. Yeah, and then I wanted to read off a certain part of the dissenting opinion and just kind of get your thoughts and takes on it. So, of course, in the dissenting opinion written by Justice Sotomayor and then joined with Justices Kagan and Jackson, they wrote, quote, "Instead, the majority focuses almost exclusively on the needs of local governments and leaves the most vulnerable in our society with an impossible choice: either stay awake or be arrested." So, with this dissenting opinion's claim, do you believe that this is a misinterpretation? And what are some of those implications of this misinterpretation lead to?
There's two problems with with the position that she took and what you just read. Number one, it's not factually correct. If you look at the ordinance that was involved in this case, the possibility of arrest was about 3 or 4 steps down the pike. it started with a warning. It started with possibly a small fine. You didn't get to the possibility of arrest until a homeless person violated this ordinance 3 or 4 times. So the choice is not simply, you can't sleep anywhere, or boom, you're going to be in jail. It's just not true. And they had to know that. They put it in those terms to try to make a point, but they were just factually wrong. And second, the first part of what you read indicated where their primary focus was, and that is, how do we treat the homeless? Now, I don't want to suggest that judges should be, cold-hearted or anything like that, but that's not their job. That's not the Supreme Court's job to determine how they think the homeless should be treated, and therefore what they think homeless policy and ordinances in local government should be. They don't have that authority. So it was factually wrong, and I think it was judicially wrong. But it's a classic example of, as we've been talking about, the two different, radically different views of how much power judges should have. The fact is, it almost sounds like Justice Sotomayor was saying, the Supreme Court is going to determine what all of this is going to be about. That they're going to solve, they're only one small part of a very large system. And frankly, as hard as it is, city councils like in Grants Pass, they're the ones who have the primary responsibility for addressing these problems, not a few unelected judges.
Yeah. Yeah, very, very insightful. Thank you so much. That's all my questions.
Sure. Great questions.
Thank you.
Well, thank you, Wyatt and Jewel. And we're going to go back to Janine for just 1 minute.
I think this is a fascinating show. There are fabulous questions from Wyatt and Jewel, and Thomas. Your answers are so clear and forthright, and it's just a fascinating topic. So I asked Kathy if I could come back in because we have audience questions, so I have to make this quick. But what you just said about that the Supreme Court justice is not supposed to give her, opinion about how she thinks this should have been done. She's just supposed to make a legal decision and not what she thinks. And I also think it's, or he, in whatever the case may be, I think it's really frightening that she propagandized something like that in such a way where she said, oh, you're asleep and you're going to wake and you're going to go to jail, and how that wasn't even the case, that there are 4 steps to get there. And I think that's really what's the word, not just, I can't think of the word, but it's not right that she would do that, because it inflames people based on something that's more propaganda than it is really a fact. And I think that's disappointing. But can we just go back a little bit? And I just want to reiterate again what you keep talking about, Thomas, and all the great questions. This is why you don't want to give 8 people in a court that there are 1 or 2 or 3 people all the power, or 4 or 5, whatever, majority, to make the decision over a group of 2,000, 3,000, 4,000, 5,000 people in their township, where they should make their own laws and create, have their own little, local government, and to give it to one person. No, that's not even what we want to be doing in this country, 1 or 2 or 3 people. But can you just clarify this for our students watching? This was the case that homeless people have the right to camp regardless of what the city ordinance is. And then the court decided, no, the homeless don't have the right to do that. They have to abide by the rules. You just want to just lay it out. This was the case, and this is what they decided, because that's kind of what this whole show's about. So I just want to make that really clear in like 60 seconds.
The city of Grants Pass passed an ordinance prohibiting camping in public spaces. Some activists for the homeless said that ordinance violated the 8th Amendment because it was cruel and unusual punishment. And the Supreme Court said no. When the 8th Amendment says punishment, it's talking only about punishment. It doesn't dictate to local governments what they may and may not prohibit as they're trying to deal with these problems.
So what is their definition of punishment then?
Punishment is the penalty that's imposed for violating a law. Could be a fine, could be jail, could be the death penalty, but it's the punishment for conduct that has been prohibited. It's not what conduct has been prohibited in the first place.
Right. Okay. I just thought we would kind of clarify that whole situation about, black and white, what happened. Okay. Thank you very much.
Well, thank you, Janine. And we want to take a moment to recognize the students that are watching today. We have D'Angela Hines with students from the Emerald Coast Christian Academy, Hope Mucklow and Cami Winehouse with homeschool students watching. We also have one of our contest winners on. Maya Morton is in the audience, one of this year's contest winner. And we have Lawson Barclay, one of our past year's contest winners watching. So we want to thank all of our students who are joining us today. We also want to thank our listeners in Las Vegas. And Las Vegas is KKVV 1060 AM on your radio dial. KKVV airs these programs on Mondays at 6 p.m. Eastern. So thank you to everyone listening in Las Vegas. So Tom, Julianne Smith asks, how do you envision cities changing policies after this decision?
Well, that's a great decision. I think the people and towns and states and all that weighed in on this case indicates that this piece of an approach to homelessness is very common across the country. There are many, many localities that have this kind of policy. And, obviously here you have the U.S. Supreme Court, not just the Ninth Circuit for purposes of a few Western states, but here you have the U.S. Supreme Court saying the Constitution does not take this off the table. So it gives them the thumbs up that they can go ahead and pursue policy approaches like this, and they're going to continue to do that. And I think, hopefully, as we were saying before, the Supreme Court, indicating that, look, this case may have to deal with homelessness. Other cases have other subject matter, but we're saying really clearly, courts, when you're going to have cases like this and where someone's saying that a local policy violates the Constitution, don't get too creative and crazy in interpreting the Constitution here. It's got to be clear. Otherwise, let local government do what it's there to do. So it does give the thumbs up for policies like this that local governments have been trying. They may or may not have success with it, but they now know that the Constitution doesn't get in their way.
Well, thank you. And then Julian also asked, were there any concurring opinions, but for different reasons? Or in the majority opinion, did they all pretty much agree?
Boy, terrific. You guys got the best questions. We mentioned the dissenting opinion, Wyatt had quoted from that. Justice Thomas had a concurring opinion. He said he agreed completely with the majority as far as settling that question. As he sometimes does, he also commented that one of the Supreme Court precedents in this area that was involved in the Ninth Circuit, getting the decision wrong. He said that was a problematic precedent, and if the Supreme Court has an opportunity, they should, overrule that decision. That was sort of a little bit of commentary on his part, but sometimes he points out how he points out the roots of some of the problems that arise in an individual case. And he was saying, Supreme Court's gotten a few other things wrong, and that's what leads to some of these, kinds of problems. So one concurring opinion by Thomas, and then there was that dissent by the three justices.
Well, thank you. Now, one of this year's contest winners, Mia Morden, has a question. She asks, how would cities enforce this policy if they don't have the facilities to support the homeless population? Example, not enough shelters and too many homeless.
That's a real problem. I when I reread the opinion just earlier today, knowing that we'd be discussing it, I was reminded that, and it was surprising to me, but many cities, I think Portland, Oregon, for example, 70% of the attempts to bring homeless people into shelter are rebuffed, are declined. It's not simply a matter of you have X number of beds and X number of homeless, and the assumption is that every homeless person would take a bed if they could. That's just not true. And that's a really complicated problem. Not only how do you solve it, but you can't have just a simplistic equation that said, well, the city shelter has 150 and there's 175 out there. But it is a problem in those jurisdictions where the problem is bigger than the solution. Here in Washington, D.C., that's very much, I think that's very much the case. And that is, I don't know, that's a hard problem. And cities have to decide, they have to prioritize their spending. Government spends at all levels, spends a lot of money on a lot of nonsense. And some of these problems are worse than they need to be as a result. But that's just an example of how complicated this problem is.
And I know there's government solutions. There's a lot of great nonprofit solutions as well. I've served on.
That's so important. The opinion also pointed out that I think nationally, approximately 40% of the space that is made available for the homeless is by the private sector. And that's, and we've got arbitrary limitations sometimes on particularly religious organizations, that Catholic social services, or where some of these politically motivated policies in big cities put a muzzle on some of these religious charities that for 150 years have done wonderful work. And that contributes to the problem as well. But yes, the private sector, especially religious organizations, have been toiling mightily for so long and selflessly to contribute to the solution.
We have some listeners weighing in on some different solutions. Robert Zimmerman says, should some be possibly forced into institutional facilities to address their addictions if that's the cause of homelessness?
Well, no, I would say to the short answer to that question, but it does raise, and Justice Gorsuch, when he wrote the opinion here, he did note, he spent quite a bit of the space in the first part of the opinion, I thought, really thoroughly going into the different dimensions of the problem. And the significant percentage of the homeless who have either mental illness, addictions, or both, complicated even further. I don't think forcing people, unless there's some kind of a danger to themselves or others, I don't think government has the right to force you to address your personal problems in their way. But it does indicate what a very complicated issue this is.
Well, Joel Silverthorne from Garden Grove, California, says that in his local community, when they remove an encampment, they will actually list that 3 accepted help, 2 ran away, and 5 were arrested for not leaving. And so that's just one example, I guess, of how different communities handle this problem. And
yeah, different communities have different mixes of just people who live there, the role of religious organizations, available social services, etc., and even law enforcement too. Different kind of mixes of those things, different environments, or kind of a different culture that exists from community to community, that makes addressing a problem like this more or less difficult. But you know, if you're a law-abiding citizen, a property owner, you take care of your family and you pay your taxes, I do think it's important for those people to see their elected officials, to see the law enforcement in their community uh, taking appropriate action on their behalf, not ignoring the law, not acting as if their interests and their rights don't matter. I think that's important too. When government kind of shies away from enforcing laws like this, that sends a message to the majority of the community that frankly, we don't think you're all that important. And I don't think that's good for the community either.
And then Rudy Melendez asked just a general question that I think is just a great closing question for this episode. That activist judges are a problem in this country, and our judicial system in general has become hyper partisan. Rudy says, which has become evident with some cases that have been labeled lawfare cases. And what is your general comment on how can we as citizens ensure that the judicial system is playing its proper role and not becoming too activist in a partisan type nature?
Well, we have to start from scratch in terms of, like I said, the Declaration said you have a foundation of principles and an organization of powers. Understanding what that design is. We all know whether it's, you know, when my mom was baking a cake, you know, she knew you got to put the ingredients together in a certain way. Otherwise, you're not going to like what comes out of the oven. We have to understand the design of our system. How's it supposed to work and how important it is for it to work that way. And then we have to resist the temptation to just want what we want, however we get it, right? I mean, the separation of powers in our government means that, well, something might be okay to achieve, but it's got to be done a certain way. The legislature has to do it, or the executive branch is supposed to do it. And it matters a great deal whether it works that way or the ends justify the means. And we really have to have a conviction about that. You know, I gave you guys a thumbs up and I'll do it again. Read your Constitution. Everyone, read your Constitution. Our founders were, every country has a written constitution now. There weren't any in 1787. They came up with the idea of how important it would be. Read it. We all know what a rule book is. If you went to a baseball game and the umpire was playing fast and loose with the rules because he wanted one team to win, everyone would know that's wrong. Well, it's an awful lot more important when the Supreme Court of the United States, using the supreme law of the land, plays fast and loose with our rights and with our freedoms. Unfortunately, there have been polls in the last few years showing that more than 60% of Americans think that the Supreme Court decides cases based on politics rather than law. I don't believe that that's true in most cases, but people have been led to believe that, and it's because they don't understand the way the system is designed to work. Ignorance is a terrible thing to manipulate. And so hats off to you guys for trying to address that. And we need to do better as citizens to really understand and appreciate how our system works.
Well, thank you. That's a great note to end on. Thank you so much for being our guest today. Thank you for all the work the Heritage Foundation and you do at the Edward Meese Legal Center there at the Heritage Foundation to promote the Constitution as well. And we want to invite our listeners to come back next Tuesday, July 23rd, 2 Eastern. We're going to be talking about some very important decisions that were made by the Supreme Court that are going to cut back executive branch power. We're going to be talking about Loper Bright Enterprises versus Raimondo and Relentless, and the Department of Commerce, which is the Chevron deference case. So
that'll be a terrific discussion.
Yes, we're excited about that. So see y'all next week. And thank you again, Tom. Great show. Thank you so much.
Thanks, everybody.